Okay, jurisdiction. Right there. The power and authority constitutionally conferred upon or constitutionally recognized as existing in a court or judge to pronounce the sentence of law or to award remedies provided by law upon a statement of facts proved or admitted, referred to the tribunal for decision, and authorized by law to be the subject meaning sub, like submarine, subsurface, below, authority, subject of investigation or action by that tribunal. So right there they're telling you, your public servants are saying that you are below them because you had kids and got divorced. Now they're saying that they are above you. They're not proving it. They never will prove it. They can't prove it. They're saying it. And, we, the people, we're the ones, it's our fault. We're being dumb enough to allow. We're being dumb enough not to challenge them. We pay their salary. They're driving around in nice cars and living in fancy houses, putting their kids through the best schools because of us. Everything they do is because of us. They have nothing without us. I saw a Judicial Watch video the other day. Nancy Pelosi riding around in 58 flights. Ran up $100,000 worth of liquor tab. 58 flights that we paid for. Ran up $100,000 of liquor tab that we're paying for. Okay, so jurisdiction simply means authority. That's the basis of it. They only have authority to enforce substantive law. Substantive. It's got to have substance. That part of the law which the courts are established to administer. So courts are only established to administer substantive law, as opposed to the rules according to which the substantive law is administered. So that means right there it's opposed to the rules. Now the rules are procedural law. The technical aspects of a legal system that states the steps that need to be followed while enforcing criminal or civil law. So even there, it's about the law. It's not about agency regulations. Adjective law. The aggregate rules of procedure or practice. That's where your federal rules of civil procedure, federal rules of criminal procedure, federal rules of evidence. You even have state rules of civil procedure. So this is your adjective law. It's opposed to the body of law which the courts are established to administer, called substantive law. It's rules of procedure. Remedial law, that's the one that we need to know about because that's the one for enforcing our rights. Remedial law. Okay. Now, so far we ain't seen nothing that showed anything about any kind of administrative regulation or business rules or see, you have to sign up for that crap. You got to sign up for it. That's why child support is voluntary. You got to consent to it. You got to volunteer for it. And I'm going to prove that before all these videos are done. Okay, while the Constitution of the United States divides all power conferred upon the government and legislative powers, I'm reading this for a reason. The executive power and the judicial power. It does not attempt to define those terms. To be sure, it limits the jurisdiction of federal courts to cases and controversies. Now, you have to prove that there's been a constitutional violation and you have an injury, and it can be remedied by taking such action. And you have proof that the state, whomever did it, so that, the state, they're going to claim immunity anyway. They shove it all off. You have to sue the agency, but you can prove that the agency did it. But anyway, it does not attempt to define the executive inquiry. See right there. Why I'm reading it. That's all the executive has the right to do, is to ask questions and enforce the law. That's what executive means. They execute the law. The legislative branch writes the law. The executive branch enforces the law. The judicial branch determines whether the law was broken. That's the way it works. Executive agencies have no authority to write rules and dream up all kinds of crap that, like in the state of Florida, they augment the laws. Executive agency can't augment anything. An executive agency can only enforce the law as it's written. And they know this. Anyway, over the years, our cases have established the irreducible constitutional minimum of standing contains 3 elements. First, the plaintiff must have suffered an injury in fact, an invasion of a legally protected interest. I'm going to cover that. Which is A, concrete and particularized. B, actual or imminent, not conjectural or hypothetical. Second, there must be a causal connection between the injury and the conduct. Causal conduct complained of. The injury has to be fairly traceable to the challenged action of the defendant. So, his action of conduct must have caused the injury, and it must be traceable to it. Not the result of independent action of some third party not before the court. That is key. Third party not before the court. Must be likely as opposed to merely speculative. So now we've got conjectural, hypothetical, and speculative. It cannot be either one of those 3. The injury will be addressed by a favorable decision. That's the third. That's how you know we're in a men's world. There's 3 legs there for standing. But these 2 first, the injury in fact and the causal conduct, nature and cause. Then it has to be redressable. That's the 3 legs, but there's really only 2 because you can't bring somebody who's been murdered back, but yet they always, award something to the victim's family or whatever, at least justice. It's somewhat redressable because they're putting the person in prison. The party invoking federal jurisdiction. Now see, all this is federal law, so it should be under federal jurisdiction. Bears the burden of establishing these 3 elements. Blah, blah, blah. I hate doing this like this. I have this over here where I could just break it up, and I've already broken it up and pulled it out, but I've got, that's actual court document, and I don't want to go showing that everywhere. Anyway, let's get to standing now. Standing in state court. A state's statutes will determine what constitutes standing in a particular state's court. Okay, well, doesn't matter. They don't have standing. There's no way that they could have standing. And I'll show you because we don't have state court. We're in an administrative agency. Standing in federal court, though, legal actions cannot be brought simply on the ground that an individual or group is displeased with government action or law. Federal courts only have constitutional authority to resolve actual disputes. This is why you got to learn federal, is because that's the only place to sue them. The plaintiff must have suffered an injury in fact. There must be a causal connection between the injury and the conduct of the person. It must be likely, rather than speculative, that a favorable decision by the court will redress the injury. Okay, well, there's some case law here. Go back, pause the video, find this page, standing. Just look it up in Cornell Law. Okay, this one right here. This is Valley. I'll show you in a minute. But anyway, respondents do not have standing either in their capacity as taxpayers or citizens to challenge the conveyance in question. The exercise of judicial power under Article 3 is restricted to litigants who can show an injury in fact. Respondents are without standing to sue taxpayers because the source of their complaint is not a congressional action but a decision, blah, 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 blah. They've not sufficiently alleged or other basis for standing to bring suit. They claim nothing else. They fail to identify any personal injury suffered as a consequence of the alleged constitutional error, other than psychological consequence, presumably, blah, blah, blah. There's no place in our constitutional scheme for the philosophy that a business of the federal courts is correcting constitutional errors. Power to dispose. Anyway, I guess I've lost it, but it's Valley Forge Christian College versus Americans United for Separation of Church and State. It's got all kinds of information in there about standing. Here's another one. Hollingsworth v. Perry. The litigant must seek a remedy for a personal and tangible harm. If you have the state coming after you, what personal and tangible harm do they have? Although most standing cases consider whether a plaintiff has satisfied the requirement when filing suit, Article 3 demands that an actual controversy persist throughout all stages of the litigation. Standing must be met by persons. Okay, see, this is still federal. The claim that may assert state's interest in the state's behalf is a fundamental restriction on our authority. In the ordinary course, the litigant cannot rest to relieve the legal rights or interests of third parties. There we go again. Third parties. It's always about the third parties. Third parties have no standing. This is Hollingsworth et al. V. Perry et al. Another really good one to read. Now, this is United States v. Mirsky et al. Okay, right here. Did you get that? United States v. Mirsky et al. Look it up and read it. It's right above 2. An administrative regulation is, of course, not a statute. While in practical effect, regulations may be called little laws, they are at most but an offspring of statutes. Congress may pass a statute. In other words, it's not a statute. It's not a law. It's color of law. I mean, it's color of law. There's no two ways around it. It's color of law. It's not due process. I've gone too far. Hang on, I'll start another one.